We get asked a lot about mediation, and a lot of people just don't know anything about it. So in Texas, it's very common for the court to require or forcefully nudge the parties to go to mediation to try to settle their differences. And a lot of judges do that so they don't have to make a decision. They would just rather keep that mess somewhere else and have it sorted out before you come back to me to rule. But mediation is basically where the parties with counsel go to a mediator and hash out their differences. In Texas, we don't do face-to-face confrontational mediation. We do it separately in separate rooms, and the mediator goes back and forth. And the mediator basically tries to come up with a final agreement that will settle and resolve all the issues in a divorce. So a litigated divorce in Texas, and let's be clear, the whole process is litigation, but what most people refer to as a litigated divorce is when we're going to ask the judge to make decisions versus when we go to mediation or we do some kind of a settlement conference or we get a settlement agreement. If we're not doing any of those cooperative settlement processes and we go put everything in front of the judge, that's litigated. And that there's a whole process for that, discovery, filings, getting in front of the court, getting court time, and that is it's a lot more complicated and very nerve-wracking for all parties involved. The cost differences between settling your divorce at mediation and settling your divorce at trial, going full litigation, they're very different. Usually a mediated divorce will settle quickly and be over way before we're even halfway through the discovery process of a fully litigated divorce. So if you mediate and settle and reach agreements in your divorce, you're going to get done much more quickly, a lot more cheaper. You're going to have peace of mind a lot sooner. And if you put it in front of the judge down the road because you just want your time in front of the judge, realize you may never get that satisfaction you want. That judge could rule against you. So I've been asked about the pros and cons of mediation. The pros are the parties come up with their own settlement. You take the judge out of the picture and you go create your own settlement. The rules of mediation are a lot looser. You get to actually talk to the mediator and tell your story to the mediator in your own words, and all those rules of evidence go out the window. You don't have any of those procedural rules, evidence rules. That's a non-factor. The cons of mediation, I can't really think of any cons. It's just a great process. Even if you don't get a settlement at mediation, you're almost certainly going to find out things that you needed to know to go forward in your litigation. If you have any questions about mediating and settling your case versus taking it to trial, give us a call at the Von Dolan Law Firm. We've done both, and we'd love to point out the differences to you.